Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is number 2023-0126, Roos versus University of Florida Board of Trustees. Counsel.
Good morning. May it please the court. Douglas Heaton on behalf of Anthony Roos. I'm here with my trial counsel.
I can't hear you.
Sorry, Justice Kennedy. Good morning. May it please the court. Douglas Heaton on behalf of Anthony Roos. I'm here with my trial counsel, Howard Bushman. So, I don't view this case as a sovereign immunity case or as a consumer case. This is a contract law case. It has that broad implication. And as such, it applies to every business and every person who contracts to do business in this state. And so every business that contracts in this state needs to be wary about doing so based on what Roos has said. Because unless your contract contains, Florida at least, contains every term of the agreement, like you actually have to provide the services that I paid you for, then you're out of luck if the state invokes the sovereign immunity clause. So the sovereign immunity question here is based solely on contract. Everybody agrees that there exists a contract here. The question is, what are the terms? And I think we can all agree that if all of the terms that we set forth in our statement of the case and facts were included on a single piece of paper with two signatures on it, on the party and University of Florida, this wouldn't be a case of controversy. It would be express contract. You had to provide services in exchange for your fees. So
I'm not sure, though, if the other side would agree with that in the sense that, I mean, part of the issue is even assuming that all of the different things that you say make up the contract are the contract, I think the question is, you know, what is the agreement? What is it that on the university side, what is it that they're being obligated to provide? And so I don't know that the sort of, whether it's 4 documents or 1 document or whatever. So, I mean, one thing that I think would help us is if you address the question of what is it that, so I know you said that you view this not as a sovereign immunity case, but I mean, it is, in terms of why we're here, it's a sovereign immunity case. So what's the connection between, if the court is, you know, let's assume there is some kind of written agreement. What's the connection between what has to be on the page versus the kind of merit stuff of, you know, what's the extent of the services or whatever? How is the court supposed to look at kind of the sequence of analysis that it's going to go through in terms of, is it just enough that there be, you know, any written contract, and is there some sort of just plausibility to the claim that then gets you to the merits phase? Or is, I mean, obviously the first TCA seemed to be baking a lot of content into the notion of what an express contract is. They were baking kind of more specificity into that. And so I guess if you could address that, I think that would be helpful.
Sure. So, and the procedural process case obviously is important because this is a motion to dismiss stage. And what they're holding essentially says is that, you know, as a matter of law, you can't plead and prove an express contract here. And we know that's not the case because the Militano line of cases, the University of Miami case, says that university bulletins and publications can be part of a contract. So the first district kind of said, well, we don't even know if these writings can constitute a contract. They kind of threw up their hands on that. Well, if that matters, then shouldn't we get to discovery on that issue? If there are some circumstances where the publications can be part of the express contract and some that they can't, then how can they say it's a matter of law that at the motion to dismiss stage, you're done? They can't. So that's why we have case law that says these documents that we're relying on can be part of the contract.
It's not so much the documents as the terms, though. So your complaint rests on this allegation that services have to be provided on campus at a specific time. And so I think that's the question, right? Does that term need to exist in the writings before you can proceed to suit in a sovereign immunity issue, or is that like an express term that's clearly outside of the contract, in which case sovereign immunity would apply?
Well, Justice Satchel, we believe it is in the contract. The express terms are there. I mean, one, you have the bulletin, which we have here.
So does your argument turn on that? In other words, do we need to determine that that express term is there in order for the suit to proceed?
Well, again, we're at the motion to dismiss stage, and so we've alleged that it's there. We've pointed to it. We've said this is part of the contract.
Right, and if the contract contradicts allegations, you've attached the contract to the complaint, and there's that fundamental rule. So is that what the argument turns on, essentially? Do we need to determine that the documents attached to the complaint contain this express term that you've alleged is in there in order for the suit to proceed?
I don't think there's any dispute as to whether the terms exist. The question ultimately is, are they part of the contract or not? And then if they're not, can they be filled in by implied covenants? Okay? So we know that the contract has, I mean, you've got these bills for for activity and service fee. They're charged that. That's referred to in the financial liability agreement, the student liability agreement. Athletic fee, health fee, transportation access fee. There's specific items for those. That's incorporated in the contract by reference.
Is the website incorporated in the contract by reference?
Well, the contract is on the website.
Yeah, no, but that's not my question. My question is the website expressly integrated into the contract by reference or not?
It tells you to refer to various parts of it, Justice Curiel. It does.
So your position is that a publicly facing statement of the university's mission, programming, whatever, a website, is like what parts of the website are included? Is it just the specific links? I think you're biting off, more than you need to bite off on this one. It seems to me, I guess the first question I have is, does the finance agreement have an integration clause? Does it purport to be the whole agreement between the parties?
It does not.
Okay, that's a biggie, right?
Yes.
You wish it did, right? That would make your argument stronger.
I think it would make it weaker because all the terms would be included in that, and so if you have additional terms that are outside of that it refers to.
Yeah, but you can't have it both ways. The reason it would make it stronger is because if you're right that it does incorporate the website by reference, then it would have it would say, I've incorporated these terms by reference, and also this is the complete agreement between the parties. That is a perfectly effective document. My quarrel with the website portion of it is there's no way to say that those messages are specifically incorporated by the parties into their agreement, to my mind, in a way that, these are public statements. They're directed at the world, right? They're not reps and warrants to an individual.
They are an explanation of the meaning of transportation, health access, and athletic fee that are absolutely, indisputably part of the contract.
Okay.
And so in that context, you can consider it to be parole evidence. And that's absolutely acceptable to use in that fashion.
I tend to agree with you that this is less about contract formation and more about breach. To my mind, what we're really here about is whether a specific breach that's been alleged is one for which sovereign immunity has been waived. Because I don't think we can argue that a contract exists. The trouble for your side is that it seems to me that some of the broader statements about facilities, for example, are about the general welfare of the university. And there seems to be a meeting of the minds between the parties that sometimes my tuition dollar will be used for services that I may not avail myself of, that are for the general welfare of the university, that are for the upkeep of the university, the perpetuation of its mission. How do you respond to the fact that a breach of that is the kind of breach that the state has waived sovereign immunity for?
Well, I think that if you're talking about tuition and general welfare, we're far more specific than that. We have 4 fees that are specifically designated. They're required by Florida law. Florida has to charge them, and they're designated to perform the activities that are described in there. And then there is a description of what you get in exchange for those fees. And off-campus students don't have to pay them.
Counsel, let me related to this, let me ask you about the relationship of the statute related to student fees to the contract that you've alleged. And specifically, I'm talking about, as you know, 1009.24.
Yes, Your Honor.
Now, am I correct in understanding that it's your position that the relevant provisions of this statute are implied terms of the contract?
They're incorporated as part of the contract.
Okay.
Yeah.
Related to what my colleague was just suggesting, how do you deal with, I guess it's 10B,
The activity and service fee?
right, where it says the student activity and service fees shall be expended for lawful purposes to benefit the student body in general. It seems to me, when I read that, that suggests that this is really something closer to what the university is arguing. It's more like a tax. This is for the benefit of everybody, and even students that don't participate in any of those things have to pay it. You can't opt out of it. It's not a pay to play sort of thing. You got to pay it as part of being a part of the university community, whether you access it or not. Same for the transportation fee. You have to pay that regardless of whether, I may want to ride my Harley. I ride my Harley. I don't ride buses. But I still have to pay the transportation fee. So it seems like if we look at the structure of this statute, just as a matter of not even just putting aside the sovereign immunity question, as a matter of just contract interpretation, once you accept that this is part of the contract, that what is provided for here does not give an individual right to access particular services at a particular time.
Well,
but it's more a means of collecting revenue for the university to use to establish the infrastructure for these services.
Well, I would disagree that they can just use them for whatever purpose. I mean, they're specified for specific purposes. The activity and service fee is different from the athletic, health, and transportation fees in that it has that more general clause. The other three fees don't have that clause that you read that says for the benefit of students. But that goes to, again, why discovery would be useful, because going back to Justice Corriel's point, if in fact they didn't spend that money for the benefit of the students, then they're in breach, right? Because they didn't comply with that term of the contract. But we don't know that because we were not entitled to discovery because of the motion to dismiss stage. So maybe perhaps the activity and service fee is not recoverable because they did as they're required to under the statute. But they definitely didn't provide any athletics. They definitely didn't provide any health services, and they definitely didn't provide any transportation.
Even you look at
during the
athletics,
pandemic.
there's provision there that they can spend it for transferring. What is it? The conference they're in. I mean, there are things about this that really are throughout this statute. It seems to me, when I look at the statute as a whole, that point in a different direction than what you're suggesting about the way it would be interpreted. Well, the way it would be properly interpreted. I mean, just reasonably interpreted, looked at in its entire context.
We also have University of Florida's own words as to how they're going to spend those fees. They're creating an obligation on themselves in addition to the statute with the activity and service. It says participation in recreational sports and intramurals, access to recreation and fitness facilities, and participation in programs like Gator Nights. Those things obviously didn't happen. So if UF says we're going to allocate these funds to these activities, we're not providing any of these activities during this time frame, they haven't spent the money. So again, I think that goes into discovery, and that's the ultimate question here.
But can you clarify though, because I think that this gets to the sort of the difference between the sovereign immunity issue and kind of the merits issue. These are kind of merits type questions, and I think one thing that we're probably all trying to figure out here is what would the discovery be directed toward? I mean, it seems like with the agreement part of this has to be limited to the words on the page, and then the question would be, what is the content of the agreement? So when the university says, in exchange for your tuition, we're going to provide you educational services, do these things that we're talking about, are they under that umbrella? What would go into defining that? Would it be custom usage, what's said on, in these things or whatever? And so I guess one thing that would help us, I think, is to hear you tell us how do you see this playing out? I mean, what is the point? As opposed to these questions seem like they're going to Why can't we just, if we put the sovereign immunity thing to the side and say, you've done enough to sort of get past that hurdle? But it's still possible that if there's only kind of, one reasonable way to read the contract, then it becomes a merits issue where you would potentially lose on that ground. Why is that wrong?
I think custom and usage is something that you would look at in discovery. You take discovery and say, okay, this is what you described you're using these fees for. Confirm, in fact, that is what you used them for in the past. And then how did you use them during the pandemic? You didn't spend them on anything. You didn't provide any of these services. All that would be confirmed.
Well,
and so
bus drivers still got to get paid. And I mean, not to get into a merits debate, I don't think it's fair to say that they didn't spend them on anything. Your unjust enrichment claim was dismissed, right? That's not before us.
because you can't do that against a sovereign immunity.
Okay.
Yes, right. Correct. But again, how much? What did they pay for? And the money that they didn't expend, there isn't a carryover provision like there is for the activity and service fee. So it needed to be expended during that student year. So what's left over should go back to the students. I mean, this is why the discovery is important. These are fact questions.
So you're suggesting that, for instance, on the health fee, that whatever they don't spend within the year, I mean, regardless of whether they're shut down or not, if they don't spend everything that's collected for the health fee during that year, that there's got to be some kind of true up at the end of the year for all the students. That sounds like what you just said.
I'm not, Your Honor. Because during that year, they will have provided services to students in exchange for that fee. Here, they did not. That's the whole point. The students did not receive anything for their money during the time it was shut down. That is the breach. The students didn't receive anything.
Subsection B, 9B, says unexpended funds and undisbursed funds remaining at the end of fiscal year shall be carried over and remain in the student activity fee and service fund and be available for allocation and expenditure during the next fiscal year. So they can carry these things over.
That's only for one fee, Your Honor. That's correct. That's the service and activity fee. That's what I mentioned before. That clause is not in the other fees.
Well, but it seems like when you just responded to what I said, you indicated that you thought it could be carried over.
I was referring to the service and activity fee.
Well, but what I asked you was about the health fee. So, okay, let's go back to that.
I didn't suggest that with the health fee. I'm sorry.
Okay, let's go back to the health fee. Yeah. Is it your position, aside from the fact of whether it's been shut down or not, that there's some right that the students have to ensure that all of the money they spend or they pay for the health fee is spent during the time they're there, that they are there, and then during that semester? And if the university does not spend the full amount of that money at the end of that semester, they're entitled to some sort of rebate for the amount that was not spent.
No, Your Honor, that's not what I'm suggesting. I'm simply saying that.
Well, so how does that differ? In effect, if that's the way you understand it, how does that differ from this provision that Justice Labarga just cited?
One part of the statute says one fee can be carried over. Other parts of the statutes do not. But we are not suing based on a pro rata refund for some services. We're suing based on receiving zero services in exchange for that. And that's the benefit of the bargain here. Okay, the students paid a fee and got nothing in return. And what the First District said is because the contract did not say that we actually had to provide any services to you, we didn't have to provide any services.
But isn't it the reality that, for instance, for the health fee, many students may never get any benefit from that because they're not sick. They don't access the services. They don't want the services. They've got something else that they access.
But it's available to them.
I understand that.
It wasn't available to them here.
But they don't have a choice about whether they pay it. They may have great health insurance, but they've still got to pay it, right?
That's correct. But they get a service in exchange for it if they want it. Here they did not. Here they paid something and they received nothing in return, and that is a breach of contract. I'd like to reserve the rest of my time for rebuttal, if I may, unless you'd like to give me more time.
So specifically for the sovereign immunity issue, you've alleged a very specific time that these services have been offered and a very specific remedy. We have Morielli, which distinguishes between terms that are expressly in the contract for purposes of sovereign immunity, which would allow the suit to proceed, versus terms outside of the contract, in which case would be a bar to sovereign immunity, even where a contractual relationship exists. So fitting this into the kind of Morielli framework, why are the terms that you've alleged not those extra contractual terms that would bar a suit based on sovereign immunity?
Well, I read the City of Brevard versus Morelli. I read that to allow for the implied condition or covenants of the contract.
Right, covenant
So
is
that
fair
doesn't render
performing,
them
but you're
unenforceable.
doing much more, you're alleging much more than a covenant. You're adding on express terms to a contract. So when services must be provided is not a condition or a covenant. It is an express term to a contract. The specific remedy that is provided under a breach is a specific term of a contract, not a covenant.
I disagree that a remedy is an express term that has to be in a contract. I don't think any invoice has to say, if I don't provide you this service, I have to give you your money back. That's implied. That's the good faith and fair dealing. We couldn't do business if that had to be in every single contract invoice. So I think that providing a service that when you say, I'm going to charge you $50 to repair your refrigerator, if you don't repair the refrigerator, you're in breach. It doesn't have to say, I will actually repair your refrigerator in exchange for this money, and if I don't, I'll have to give you your money back. It doesn't have to say that. Those are implied covenants, and that's what we're filling in here. We have fees charged for specific services, and it's an implied covenant that you actually have to provide those services in exchange for those fees, and if you don't, then you need to give them back.
Yeah, and we'll give you more time, but let's clarify this, because the opinion talks about, I know that you're saying there's specific fees and there's specific services associated with those fees, and in the opinion in some of the questions, there's reference to you also alleging specific times. And so A, is that true that you're alleging specific times? Because I don't know that I saw that. And does that mean this semester that I'm paying for, or does it mean that, the buses have to run on a certain schedule, or the health center has to be open, or the gym? Could you clarify what exactly the allegations are on the time
It's
part?
during the semester that the student is attending. That's the time frame that she was referring to. It's not at 8 p.m. or anything like that. It's yes.
So it's basically
while I'm a student
the
there,
student
and I
is
pay
paying
the
for a
semester.
certain semester, and you're saying during that semester the services have to be offered.
That's correct.
That's what we're talking about.
That's correct. That's correct.
All right, you can have 5 minutes for rebuttal.
Thank you very much.
Mr. Chief Justice, and may it please the court, petitioner's complaint does not support, and it actually negates the existence of an express contract to waive sovereign immunity. Therefore, it was properly dismissed. Petitioner alleges his complaint and attachments are a, quote, express contract for specific on-campus services during the spring and summer 2020 terms. Yet none of the attachments state the parties agreed to such specific services, and the web pages are non-exclusive examples of possible uses of the fee. And importantly, petitioner alleges that the fees must be for statutory purposes, but 1009.24 provides many other uses of the fees, including capital outlays and transportation infrastructure.
Why doesn't your argument absolve the student then of tuition? Like, to what extent, are the students, I guess we should start with that. You concede that there is a written contract in this case about the payment of tuition. You do.
Correct.
Are there any fees that you would concede are contractual in nature, that there is a contract that is binding about?
Your Honor, so for the four fees that he specifically seeks, there is no express contract for those fees.
So no.
No.
Okay. So is there anything on the face of this agreement that where you direct me as the dividing line? Because if I'm a student and you're telling me you don't have these obligations, I'm trying to find where in the document I'm told that you have a contract as to some of my financial obligations, but not as to others.
Sure. So in the financial liability agreement, it says that payment of tuition, fees, other charges expressly gives you the right to enroll. Okay, so that we admit is a contract.
So from a sovereign immunity standpoint, I just want to make sure that we walk through the implications of what you've conceded. If a student brought an action and said, I did not receive educational services as defined, and I paid tuition, you would say the university has waived sovereign immunity as to that claim.
We would say that if a student paid tuition, fees, all the charges.
No. Focus on the tuition for me.
Correct.
If I'm a student, if Rojas had said, the services I received were so bad that they do not constitute educational services as defined, and therefore I want my money back for my tuition, would sovereign immunity be waived as to that claim?
We would say that that financial liability agreement does make an express contract between the payment of tuition fees, as it says, and the right to enroll.
So yes?
So that's all
clear.
you're getting is the right to enroll.
For the payment of tuition fees.
So your answer to his question is that
Yes.
as far as educational services, the meaning of that term is the right to enroll. Because I think he's trying to put some meat on the bone of what
That's right.
educational services is.
That's right. So the agreement says expresses the right to enroll, and it says you get the value of education.
Could I take it one step further? Because this example was about a claim that the services were inadequate or deficient in some respect. What about a circumstance where everything was paid as it should be paid for a particular course, and the student registered for the course, and then the university decided we're over-enrolled for that course. You can't, unfortunately, we have an over-enrollment and you cannot participate in the course. Would the student have a claim to get that money back?
So I think the court can evaluate what the right to enroll is, and so it's the ability to choose classes. I don't think there's any expectation that a student's going to get every class he or she chooses at the time that they expect or want to get it. So in that sense, no. I don't think you have a claim for every possible wish and dream of your class schedule. But I think if the right to enroll was completely denied, then certainly there would be a claim there.
So why isn't, though, it seems like the most straightforward way of looking at this, and this is maybe what the Kentucky court was doing, was to say, look, there's a written agreement here, which that's all, express just means said, it's laid out in words as opposed to conduct. So we have a written agreement that says the student pays tuition and fees on the one hand, the university provides educational services on the other. They're saying that educational services, I think part of their argument is educational services includes this basket of things, everything from the classes to being able to ride buses to health care, et cetera. They're saying that if I enroll as an online student, I don't have to pay for these fees that are in dispute and whatever. So why isn't it enough to at least get through the sovereign immunity hurdle to say, look, we have a written contract. The fight is over what does educational services means. As a matter of basic contract law, there's all kinds of stuff that could go into that. It could be reading all the other documents together with that term. It could be custom and usage. It could be whatever evidence that might shed light on what the mutual understanding of what that was, including just a traditional expectation that you're not going to get every class. Just like there's maybe a traditional expectation that sometimes the gym's going to be closed for renovation for the semester that you happen to be there or whatever. Why isn't it just a basic contract case like that, in which case they would have a right to at least get past the sovereign immunity point?
I'd say for two reasons. So the Kentucky case, waiving sovereign immunity in Kentucky, is based on just a written contract.
Fine. I don't know that express, comma, written is any different. Express just means in words.
Well,
express doesn't mean it has, I don't think that we could live with a rule in practical terms that said the state can only bind itself to contracts that are so clear that as a matter of law there's no ambiguity whatsoever. I don't know if the world could function under that regime, and Pan Am certainly doesn't say that.
Well, could the state function under that? Yeah. Because this is a two-way sword.
I think the statement of express is that both parties state what the agreement is. So it's not just a one-sided piece of paper. But the second point is that in Kentucky, there were 18 specific services that the contract said would be provided, and none of those were provided. Here, you've got the petitioner incorporating in the statutes as part of his contract. That is part of his complaint. And of course, there are other uses of these fees than the very thing he's seeking. So the
But
statute.
that's kind of a merits issue, though. I mean, they're saying basically, and especially I think that the whole online thing, and I don't know what the right answer here is, but this is it's everybody, I think if you read 50 of these cases, everybody acknowledges that the university-student relationship is very unique. But I think in this case, the fact that the university charges these fees and gives these online students, the option not to pay them kind of on the assumption that they're not, either that they're not using or that they're at least not, being offered the same thing as these other students. And then through no fault of anyone's, the pandemic comes along, everybody becomes a de facto online student. At least according to the allegations that we have to accept as true, the buses stop running, the health center closes, the gym closes, there's no sporting events or whatever. I mean, it doesn't seem implausible to suggest that something that a student would have rationally thought they were bargaining for just isn't being provided. And the question is, who's going to bear the brunt of that? Is it going to be the student or the school? I mean, so as far, and I think that's a very complicated merits question, but I don't know as far as just did they allege that we had an agreement and have they alleged that there was a breach? I don't know why that isn't enough to get past at least the sovereign immunity hurdle.
Well, I'd say two things to that. I mean, one, petitioner never disagrees that the University Act reasonably, actually, he says they did. So student expectations, certainly they think that, maybe I can go to the rec center, but if the rec center was flooded, no student would expect to be able to go to the rec center while water's there until it's dried out, right? So those expectations are not written into any express contract. But I think more importantly, is when the court is looking at the petitioner's allegations, they're looking at the contract that he provided. And the court should do that at the motion to dismiss stage. And the contract he provided incorporates the statute. So the court can look at it and go, okay, the relief he's seeking is on-campus only services during the spring and summer 2020 terms. Is there any possible other use of those fees in the contract? And the answer is, of course. The statutes give all kinds of other uses of the fees. So even for those students that are traditionally on campus and would pay the fees, those fees could go to capital outlays.
But then why does the school offer these two packages? It seems like everything would make sense if every UF student paid the same thing, and then it would be more like a tax.
I think that again, petitioner doesn't say that UF offered nothing at all for the fees, and he doesn't say UF acted unreasonably. I think in a normal environment, things like going to the rec center would be available, but they're not required, and that's the difference. And Justice Sasso, you asked about Miorelli, and the key in Miorelli is a question of scope. The court said there that even if we agree that contract principles apply in the analysis, that, quote, the binding the sovereign to implied contracts is different from requiring the sovereign to pay for work beyond the contract. And so in Miorelli, you had a contract to update an airport in a suit for extra drainage work, additional drainage work. And the court said that additional drainage work is outside the scope of this express contract. Same thing occurred in Southern Road Builders, where the third DC on a motion to dismiss said the express contract is to build the Marlins facility, and that there was extra work outside the contract. That extra work is brought into the express contract. And the same exists here, where a petitioner is saying the express contract is for on-campus services at a specific time, but we know the contract provides for other ways to use the fees. So there's no required or reliance on on-campus only fees when students pay these various fees. There are other uses of the fees.
But they aren't alleging, isn't their point though that there wasn't really any substitute that was, so the health center is closed so you can call and get a teledoc or something or whatever. I mean, and again, at this stage, we are working off of their factual allegations. I don't think none of us, we don't have any idea what exactly the school did and what it tried to do to kind of give people the best substitute they could or whatever, but just based on their allegations. I mean, they're basically saying you didn't, it's not just on campus, they didn't offer us, we paid for X, Y, and Z, and it all went away. That's the allegation, right?
Well, they say that, but the contract that they provide is different. And so we believe a court at a motion to dismiss, because the contract under Florida rules is required to be attached, because there's a difference between notice pleading and fact pleading in federal and state courts, and this is part of the problem with Moore, is it had more of a notice pleading standard. But the court can look at the contract. And if the court can look at the contract on the motion to dismiss and go, the relief you're seeking is not required, it's not relied on, it's not mandated by this express contract to provide tuition and educational services. If something else in the contract on the pieces of paper that are attached to this complaint can be provided, it's not express, because the relief he demanded isn't the only way for UF to use those fees. If there are other questions, then I will turn to the Attorney General's office.
Thank you.
Good morning, Mr. Chief Justice. May it please the court, Miles Lynch on behalf of the state of Florida. Under the Florida Constitution and this court's precedents, sovereign immunity may only be waived by the legislature through general law. As the party claiming the state waived its sovereign immunity, Rojas had the burden of identifying such a law in his complaint. He did not attempt to meet that burden. He misinterprets this court's precedents as saying that a state official waives sovereign immunity by entering into a contract. Some district courts have interpreted them the same way. To clear this confusion, this court should reemphasize that the legislature waives sovereign immunity from contract actions by authorizing a state official to enter into that type of contract. The state official entering into the contract does not and cannot waive the state's sovereign immunity themselves. This court should also emphasize that parties bringing contract actions against the state bear the burden of identifying the general law authorizing that contract. Had the district court required Rojas to identify which statute waived sovereign immunity before moving on to the existence of a contract, it would have been clear sovereign immunity was not waived. The only statute that Rojas seems to be relying on here, Section 1009.24, does not authorize the university to bind itself to provide students the requested services in exchange for the mandatory fees. It basically creates a government taxpayer relationship.
Doesn't require it, but it certainly allows it to, right?
Correct.
And once it has availed itself of that permission, then what?
It has the authority, just as any other government entity would, to provide the services.
Right, but doesn't that constitute waiver? I mean, if the university avails itself of the terms of this statute by doing what it is allowed to do, how is that anything but a waiver of its immunity to be sued if it fails to perform what it undertakes to do?
Well, Your Honor, it's not just authorized to collect these fees, it's required to collect these fees. It's authorized to provide services that in its discretion benefit the student body in general in the ways that the legislature intends them to be spent. And under Pan Am, the legislature can allow the university to subject itself to contract actions by authorizing the contract or authorizing activities that, as a matter of practicality, require the contract. But charging fees as it's required to do is not any kind of commitment from the university to, or from the legislature, I mean, to provide students this avenue of relief.
What avenue of relief are they allowed?
Sorry, could you say one more time?
What avenue of relief are they allowed if they're not allowed this one? What I'm trying to expose is that you're basically saying none.
Yes.
You're basically saying the university can take their tuition, not perform any of these things, take their fees, and say you're out of luck. That's the position you've chosen to advocate for?
No, Your Honor. Tuition is separate from
Fine,
mandatory
tuition, fees.
But that is correct. The legislature has established
How is it in the interest of the state of Florida for the Attorney General to be taking the position that the universities of the state should be judgment-proof with respect to fees that they charge? How can the state do business if that's the rule?
Well, as Pan Am establishes, Your Honor, any contract that is authorized by the state or any activity that requires a contract opens the state up to relief here, or for relief for such a plaintiff. The problem is the legislature, pretty clearly from looking at the structure of 1009.24, never intended for contract actions like Rojas is bringing here to be on the table. That was the legislature's choice, not the.
Well, and so you reach that conclusion just by the way that statute is framed. I mean that it's because it doesn't seem to give an individual right, kind of along the lines of the questions I was asking earlier. Is that how you reach that?
Sorry. That in addition to how Pan Am came out, Your Honor, if the ability of the university to give these services to students relied or was required in some way, these kinds of contracts, that would be a very different question. But here, because the legislature created this quasi-taxpayer government relationship, the legislature decided to treat it differently. There's no clearly intended contract to be recovered for.
And I can't remember if you cited this in your brief, but is there a specific statutory authorization for contracts as they relate to tuition and being able to go after students who don't pay their bills?
Yes, I mean for tuition, tuition is defined as the. Sorry.
I mean, I know that it's something that has to be charged, but in terms of, I'm just wondering unless there's a statute that says the university may enter into contracts in which they will offer classes in exchange for tuition, then maybe I could see that. But if the same kind of more kind of vague idea of, hey, we're offering a service that's voluntary and we have to have contracts so that we can go after students who don't pay and they know what they're getting from us. I mean, I don't know why tuition and these things would be any different.
So tuition is defined as the basic fee charged to a student for instruction provided by public post-secondary educational institution. So there is a direct tie-in from tuition being paid to receiving instruction, and the 1009.24 sets for undergraduates, I believe, at $105.07 per credit hour of instruction.
But in terms of the authority to contract, there's no difference.
Well, it is authorizing the ability, or it's authorizing the university to charge tuitions a set amount of money to receive instructional services, which under Pan Am, I believe, would be enough to waive the state's sovereign immunity. And beyond that, the universities are also bound to give students degrees if they complete a certain number of courses and credit hours, subject to certain general education and other requirements. There are various statutes, I believe, that authorize the tuition contracts, but there's nothing similar for the fees here. So I'm running out of time. So the state respectfully asks this court, in approving the decision of the district court, to reaffirm the basic principle that parties bringing in action against the state are required to identify the general law by which sovereign immunity was waived. Thank you.
I obviously disagree with the interpretation of Pan Am, which allows the state to enter into express contracts, and it doesn't have to have a statutory basis to enter into every single express contract. The state could not do business if that's the case. This court has decided that the state can contract. But we do have a statute here that requires these charges to be brought. And Justice Kennedy, I did want to point out there is some language in the transportation fee that it says that the fee shall be used on reasonable cost of services. So there's actually a mandatory requirement there for at least the transportation fee that you got to spend it on transportation. So again, that's another reason to do discovery. Now, Justice Curiel's point is well taken that they're asking these schools to be judgment proof.
It's not accountability proof. There's all sorts of accountability built into the statute. You have committees formed for expenditure of fees, which includes students. You have these fees being run through the Board of Trustees, which itself is accountable to the executive branch. You have deposits where, accounts where it needs to be specifically deposited. So to act like the university is unaccountable to the public for the expenditure of fees is not accurate.
Well, the board and everything, that's related to the activity and service fees. I don't remember that being in any of the fees. And also, that's not accountable to the students who are actually paying for those. Because if they don't provide it to those students, what recourse do they have? They want to be judgment proof. If Rojas did not pay the fees, he gets sent to collections for those under the FLA. So they get to sue him for not paying it. He doesn't get to go to school if he doesn't pay it. But if he pays it and they don't give him anything in return, he has no recourse. That's the position that that UF is taking, that the state is taking, that Roos, the majority, is taking. Just got this right. He said that's illusory. We don't do that. It violates. We have a doctrine called fundamental fairness in this state, and the Supreme Court in 1941 were about the state doing a one-sided contract where they say we can enforce it, but you can't. It's fundamentally unfair. This violates the several writings doctrine. This violates the illusory contracts doctrine. This violates the fundamental fairness doctrine. Rojas doesn't address any of those issues. Judge Makar does. And if you look at, Regard, honestly, deals with each and every one of the arguments made by the school here. And they deal with them very well. The idea that all you're paying for is the right to register, it rejects that out of hand. It says specifically that dog won't hunt.
I don't know, but there's a lot of distance between the right to register on one extreme and the right to the level of specificity that you're arguing for. And I think, it really does. I think it comes down to the meaning of, educational services. And if this were a normal contract case, I think there would probably be a lot that would go into figuring that out. But I think at the end of the day, what you're asking for is, arguably on the other extreme end of, the position that, hey, as long as we let you enroll, then all bets are off after that.
Well, Your Honor, I don't think it's extreme to ask that someone be bound to their contract to say that when you're paying for a service that's specifically delineated for a specific purpose, that you receive something in exchange for that. I don't think the I don't think the Kentucky Supreme Court can be labeled extreme in the way that they came at this. They said that.
Can I ask you a question?
Of course.
If, for instance, 1 year, let's say not pandemic, that they used all of these fees, every bit of it, the activities went to, I believe, debt repayment, transportation went to capital improvements, all of these fees went for something allowed by the statute, but not improving the life of the student in any way, would you still have these same claims?
Yes, because if they did not provide any services in exchange for those, and they use them in manners that are not authorized by the statute.
No, they're all authorized by the statute.
The transportation fee cannot be used for capital improvement. The only thing that can be used for capital improvement is the service fee, and you have to go to and get approval for that. So if they don't actually follow the statutory requirements to do that, they'd be in violation. They'd be in breach. Absolutely. They have to follow the statute. There's nothing in the health fee.
You just described, though, isn't that a private cause of action for violation of the statute, not a contractual relationship?
Right.
No, you don't need. The statute does not need to have a private cause of action in it. You're not suing. You're suing because you did not provide the service. You're suing because you were not provided with the services that you paid for, and the defense is, well, we didn't have to provide it because we allocated all the service and activity fees this year to capital improvements. But if they didn't actually do that properly, then that would be a breach for the student, right?
What if they just transferred it all to the next year?
They're allowed to do that. They're allowed to do that, but that's only the service and activity fee. That clause is not in these other fees.
What?
And again, the transportation fee says it shall be based on reasonable cost. So that is literally, you must spend.
Where exactly is that provision you're citing? What provision is that exactly? The transportation access fees.
Yeah.
Because that's not an R.
100.2414.
There's a lot under that. Is it an R? Is it an R? Are you saying it's an R? Because that's where it talks about transportation access fees. I'm just looking for the language that you're citing, and I'm not finding it.
I'm sorry, what I have in my brief is in 14.
Well, I'm asking what's in the statute.
No, that's my brief about the statute. I've got 14, and I guess there's subsections under that.
Well, subsection R says it refers to traffic and parking fines, charges for parking decals, and transportation access fees. That's where I think it refers to that. And then it says only university-wide transportation access fees may be included. And then it talks about financial assistance. But I'm not seeing what you're talking about. I'm seeing that reference. But again, I'm not saying it's not there. I'm just asking where it is.
I'm sorry, Your Honor. What I have in here is 14. I've got, quote, shall be based on reasonable cost of services. I remember reading. I can assure you that it's in the statute, that language in reference to it. But
I'll do a search. I'll do a
My
search on Westlaw.
apologies. My apologies.
So on the, so this came to us as a certified question. Do you agree that, I guess your position is that although the question is just kind of stated in this kind of abstract sense of, is there sovereign immunity for these fees kind of across the board? I mean, it would really, if we proceeded to the stage of just sort of looking at these particular documents read in light of the statute and then came to a conclusion that as a matter of law it means X or Y, that would really be good for, I mean, there may be some kind of methodological precedent that we would be setting, but I mean, as far as, you wouldn't be able to take that and just sort of immediately kind of mechanically sort of get rid of or resolve every other case. I mean, you'd have to still look at the specifics, right?
Well, that's what I argued. I think that the certified question, the way it's written, is improper because the answer is yes. I mean, sovereign immunity can bar the claim if there's no express contract, and that's.
Well, let me ask you this.
I just think there's a bright line rule that can be designed here.
Did the district court pass on that certified question? Let me go back. To be standing here today, the answer has to be yes, right?
Not always. I mean, sometimes they send it up here without passing on that. I know we wouldn't written that before.
Well, but the Constitution says it's a question. They have to pass on the question. That's
Correct.
The only way they can certify it. And otherwise, we don't have jurisdiction. And it just looks a little. I mean.
Well, I mean, I think
pretty sketchy.
They answered
pretty
that.
Sketchy.
I think they answered that in this case, based on the facts, but they certainly didn't answer it as a general principle. I don't think because I don't think you can answer that as a general principle. Whether sovereign immunity bars a breach of contract claim against a state university based on the university's failure to provide its students with access to on-campus services and facilities. Sovereign immunity does not bar that.
I mean, if you had a contract that explicitly, and 1,000 people would agree that it said this university agrees to provide X, Y, and Z, there's nothing about the doctrine of sovereign immunity per se that would prevent that subject matter.
Exactly. That's why I have a problem with the question as it's written. And
okay. All right.
So,
do you want to take 30 seconds to close up?
Well, yes, and I'd like to end with the quote from Regard, which is that, noting that on-campus students are charged a higher rate than those students off-campus. And they said that by defining a product or service in writing and then charging a price for those products or services in writing, the university nonetheless has no reciprocal contractual obligation to provide said products and services as defined once the offer has been accepted. They term that argument sophistic. And I agree with that. That's what we're talking about here, is an argument that we don't actually have to do anything for the money you paid us. That's not contract law. Thanks for your time, Your Honor.
Thank you. Okay, our next case is number 2022-1457, Parish versus the State of Florida. Counsel.
Good morning, Mr. Chief Justice, and may it please the court. My name is Justin Karp, and I represent Mr. Parish, the petitioner. I'll reserve 7 minutes for rebuttal. Mr. Parish went to trial. After he was convicted, he asserted 2 valid statutory grounds for a downward departure: youthful offender under 921.0026 subsection L, and a mental disorder unrelated to substance abuse and being amenable to treatment under subsection D of that same statute. The trial court understood its discretion and decided not to grant a downward departure. Mr. Parish challenged that denial on appeal, noting the first DCA's opinion in Wilson, which at the time was the lead case on this issue. Wilson, which arose out of a plea, concluded that because this court or the legislature didn't explicitly say that banks extended to defense-initiated appeals, they didn't have jurisdiction to review the issue. The DCA dismissed this portion of Mr. Parish's appeal accordingly. The only question before this court now is whether a DCA has jurisdiction to review the denial of a downward departure. So starting with the Florida Constitution, Article 5, Section 4B1 authorizes all appeals that may be taken as a matter of right. Florida Statute 924.05 defines direct appeals as a matter of right. This court's opinion in Sims.
Would you concede that if a downward departure is not unlawful, not illegal, it's not unlawful, but is a downward departure, is the DCA's jurisdiction, does the DCA have jurisdiction to hear that just because it is a final judgment, even if it is concededly lawful?
I think even if you don't look at it that way, it would still be appealable as a ruling in the record, because direct appeals are plenary. So I think what's really at the heart of that question is that if it's not unlawful, it's not an abuse of discretion, and it would be affirmed rather than dismissed.
So it's a null set, right? I mean, like, I guess in order for your argument to be persuasive, what needs to happen here is that every time you talk about an appeal, I've got to imagine that it's perfectly lawful. I've got to imagine that somehow this is an appeal that is not a deviation, is an exercise of discretion, and I'm reviewing it for abuse of that discretion. And, presumptively, a sentence that is below the statutory maximum, higher than the lowest permissible sentence, and not infected with a score sheet error or any other source of unlawfulness, is, I think, an exercise of judicial discretion. So I don't know what kind of world it is where you win this case by us holding, yes, it is a plenary, like we have a plenary appeal right, it is an order that can be appealed to the DCA, but it's a null set. It'll never be reversed because it can't constitute an abuse of discretion, absent some unlawfulness.
I'll admit that an abuse of discretion is a high bar, but there are cases reversing a sentence for an abuse of discretion. Mr. Parish,
give me a case that is an abuse of discretion where the sentence was south of the stat max, north of the lowest permissible sentence, and did not contain some error or other unlawfulness.
I'm not aware of any cases.
It's a null set. It's zero.
Right. Well, I mean, you can also say that it hasn't happened yet, but that doesn't speak to jurisdiction. That speaks to whether you will win.
Imagine one that is not unlawful, but yet subject to some judicial work because it is an abuse of discretion.
Well, Counselor, would you say that this would be similar to a motion to continue, which appellate courts review all the time in direct appeals where the defense has said this was, should have been granted? It's very, very rarely do we find that that's an abuse of discretion, but it can happen, and it's not really a jurisdictional question. It's just a question of whether that is something that's frequently affirmed or not.
I would agree with that characterization, and that was going to be my response to
you got a little help from my friends there on that one.
Yes, yeah, took the words out of my mouth. But that is how I was going to answer Justice.
Love it when that happens.
Yeah.
Can you think of in the specific context that we're in, outside of motion to continue, where it would be an abuse of discretion?
Well, I would say denying a downward departure that should have been granted is one such example.
Yeah, on what grounds?
On what grounds?
An abuse of discretion. It's very deferential. Yes, I'm not aware of it ever having happened, but that speaks to whether you win, not whether there's jurisdiction.
Isn't your argument really at its core just an argument about the text of the Constitution. We got this rule stuff and the statutes, but it all goes back to the Constitution, right?
I think that's fair. I mean, as understood through the statutes and rules and relevant case law, but ultimately, yes.
Well, the Constitution says what it says.
It does.
And the Constitution says that the district courts of appeal shall have jurisdiction to hear appeals that may be taken as a matter of right from final judgments.
Correct.
And so it's your position, if I understand it correctly, that if you got a final judgment, you've got a right of appeal, and the district court has jurisdiction.
Correct.
And it's that simple, isn't it? At the end of the day.
That's the way I look at it.
We know, all of us know who've been around at all, that there are a lot of appeals that are DOA. Okay?
I can concede that point.
I mean, where there's just no plausible path. There's no plausible path to reversal.
Right. I mean, the brief cited Anders versus California. If the appellate counsel reviews the record, sees there's no reversible error, that's affirmed. It's not dismissed for a lack of jurisdiction.
Right. I mean, we've got all sorts of things like that where we know. I mean, you can look at it, and we've even got summary, and the rules, there's summary reversals where you argue something here. We don't even have to look at what the other side says. We're going to, summary affirmance. We're just going to summarily affirm. And so we know that, but that has nothing to do with jurisdiction. The fact that an appeal is a loser, and inevitably a loser, once it's described to you, does not mean that the court lacks jurisdiction under the Constitution, does it?
That's correct.
That's your position.
Yes. That really, I mean,
we'll send you a bill from the two of us.
Yeah. If there's a Venmo or something, I don't know. But really, I think that really does speak to the heart of it. If you're not getting into the nitty-gritty of the rules, yes, the Florida Constitution, it is a direct appeal authorized by the Florida Constitution. A direct appeal is plenary. It encompasses every ruling and order. Whether you win doesn't speak to jurisdiction.
Counsel, do you know of any other issue that we have found the state has the ability to appeal, which I think the statute is clear, but the defense would not, where it's asymmetrically a jurisdictional issue where there's asymmetry between the state absolutely can appeal this particular issue, but the defense cannot?
I'm not aware of any, and I think that makes sense because the defendants have certain constitutional rights. The state's rights are only conferred by statute. And if there's no further questions, I'll remain.
Can I ask you about that? I mean, how do we, and we know that from the text that Justice Kennedy just read, or is that tradition, or what?
Well, that would be the due process clause. I believe the cases are from the U.S. Supreme Court.
So you have to read because where it says, basically final orders, judgments can be appealed. Mm-hmm. It doesn't talk about prosecution and defense being any different.
No, it's
the
appeals.
reason we know it's different is because of what?
Appeals that may be taken as a matter of right. The state only.
Actually, though, I mean, I think grammatically, the only way that any of this makes sense is if the comment that may be taken as a matter of right is just sort of just declaring just kind of the reality that final orders can be appealed. If it were describing a limited set of appeals that could be taken as a matter of right, then we'd be having a different conversation. Then we'd have to be talking about history and
right.
But
the legislature.
I think part of what the state is arguing is that if we read this kind of in a larger context, and if we know that sentences within a certain range, just if the judge decides to give you 20 years or 15 or whatever, that just in our system that's just not something that can be challenged. They're basically saying this is no different, and that if we allow this appeal, then we would have to at least theoretically allow someone to say you abuse your discretion by, forget downward departures, just by the sentence that you gave me. Yes, it was within the range, but you had all this evidence in front of you about all this mitigation, and you still sentenced me this way. That's an abuse of discretion. And the reason why it seems like there's some history and background and context that kind of informs how we understand what can be appealed, and why shouldn't that be part of what we look at as far as how we're reading this?
Well, I think because per statute and rule, the state has limited appellate rights in a way that a defendant doesn't. I mean, the statutes and the rules are all cited in the brief. But
the statutes and the rules aren't. I mean, if the statutes and the rules were what controlled things, then we'd be having a different conversation.
I think that's fair, but I think that any exercise of discretion can be reviewed for an abuse of discretion. That doesn't mean you'll win, but the DCA can rule on it as part of any matter as part of a plenary appeal.
Isn't the most reasonable way to understand the fact that the state is limited in its appeals by what is provided in statute is that the legislature acts for the state? If the legislature wants to limit, and there's history behind that having to do with double jeopardy. But if the state wants to limit itself through appeals, then the state can do that. It's a different matter if the legislature decided they wanted to limit this constitutional right that is given to defendants. And so,
I would agree.
Isn't that a way of understanding the difference in the way they're treated?
Yes, it is. If there's no further questions, I'll save the remainder of my time for rebuttal.
Mr. Chief Justice, and may it please the court, Bridget O'Hickey for the state. The question before this court is whether district courts may review a claim that a trial court abused its discretion by declining to downward depart and instead imposing a sentence within the range provided for in the criminal punishment code, with nothing more. No claim that the judge considered an impermissible factor, no claim of constitutional error, just simple disagreement with the trial judge's discretionary choice. And the answer is no, because district courts lack jurisdiction to review bank step 2 denials under this court's longstanding precedent under Brown and Davis.
How does that fit with what the Constitution says about the right of appeal of a final order? I mean, there's no question this is a final order, right?
Correct.
So what's wrong with that equation between final order and right of appeal? And we know there are circumstances when appeals can be dismissed. For instance, if the jurisdiction of the court is not properly and timely invoked. We know appeals can be dismissed because if the litigant fails to follow the rules in some respect, then there's a sanction of dismissal. But aside from circumstances like that, why don't we just understand that once you've got that final order, you can go to the district court, and you may be on a mission of futility, but the Constitution says that if you've got a final order, you've got a right of appeal.
Well, Your Honor, in Article 5, Section 4B1, that language was adopted in 1972, and Davis, which was in 1960, and Brown, which preceded it in 1943, the rule from those two cases says that in a long adhered to line of cases, we have held that where a sentence is within the statutory limit, the extent of it cannot be reviewed on appeal, regardless of the existence or non-existence of mitigating circumstances. So when the constitutional provision was adopted in 1972, it was against the backdrop of that case law, such that the constitutional provision doesn't say anything about abrogating that long-standing rule. And so it's the state's position that...
Well, but it is textually distinct, right, from the predecessor provision.
That's true from the...
So can you walk us through what difference, if any, we are to give, what meaning, if any, we are to give to the change, the addition of the commas?
So the addition of the commas appears superfluous.
But we're not generally in the business of looking at changed text in the Constitution and ascribing to it randomness or meaninglessness. I mean, do you quarrel with Justice Kennedy's exposition of the meaning of the text? I think it's really important to have clarity from the state on whether there are some appeals that may not be taken as a matter of right.
The state, in its brief, hasn't asked to receive from the 1996 amendments case that does interpret the constitutional provision as providing a right to criminal defendants, a right to an appeal.
So that's a no. There are no appeals that are not available as a matter of right of final orders. Am I right?
No. We believe that the constitutional provision should be construed to
say something other than it says.
No, to be limited to what was historically considered to be appealable.
So give me final orders that are not subject to appeal. Tell me where they are. Which ones?
An appeal after a defendant has pleaded guilty, this court has said that that defendant would be limited to the issues.
We don't have jurisdiction?
And Dorch, you're referring to Dorch?
Yes.
We affirmed. We didn't dismiss.
Well, if this court is unconvinced that the Davis and Brown rule is jurisdictional, then the state would also happily accept a ruling that the Davis and Brown rule functions as a merits rule and that they're unreviewable on the merits as well.
At the end of the day, with all due respect, in this case, it's kind of a big nothing burger. Because when you get down to it, the district court has to look at it to decide whether there's some, even under your theory, they got to look at it to decide whether there's some meritorious argument. And then there's the question whether they're going to dismiss it or affirm. If there's no meritorious argument, they're going to affirm. So it just seems like we're going through all this when the text of the Constitution is so clear about this right, and we're going through all these gyrations for really for naught. I don't understand it. So help me, enlighten me why this matters.
Yeah, it matters, Your Honor, because it matters that this court reaffirm its longstanding rule in Davis and Brown, whether it wants to do that and say that the rule is jurisdictional, that in-range sentence determinations are unreviewable on the merits or unreviewable because the district court lacks jurisdiction, because permitting abuse of discretion review for discretionary Bank Step 2 denials would, as the Chief Justice also recognized, there's nothing that's distinct about exercising that discretion at Step 2.
But here's the thing. We know that things can happen in a sentencing procedure where even though the judge is acting in a discretionary way, the judge can do and say things that are going to be problematic. If the judge says, well, I would have given you a downward departure here if you had a better lawyer. That's problematic. I think most people would think that's problematic. That somehow the judge has gone off the rail. It's not really illegal. It's not that the judge has necessarily articulated a point of law incorrectly. It's just that the judge has gone off the rails. And so is that reviewable?
Yes, Your Honor. I think Florida courts have long distinguished between legal error, such as when a judge would consider an unlawful factor in exercising his discretion that might implicate the defendant's due process rights, then that would transform the sentence into an unlawful sentence, which is, of course, reviewable. But an exercise of pure sentencing discretion amounting to a claim like petitioners here that his sentence was just too harsh is something that this court has long said since 1943 in Brown and Davis that is unreviewable by on the merits or as a matter of jurisdiction by appellate
How would
courts.
you distinguish what we do when we review mitigating factors in capital cases? So when a trial judge is looking at the mitigation in a capital case, it's an abuse. We I believe, review that for abuse of discretion. They're, as far as where they're putting the weight and how much weight they give to each of those things. And I mean, we review that constantly here. How would you distinguish kind of what the difference would be in an abuse of discretion for a downward departure, where the trial judge is essentially giving weight to mitigating factors, and then how we review those cases for capital mitigators here?
Yeah, I think this context is simply different from the capital context, because as this court said in the 2021 Davis case, that the fact of conviction alone is enough to sentence the defendant up to the statutory maximum. I think that case, even if the defendant was otherwise a pillar of the community, that because the legislature has said when setting the range for a particular crime of conviction that anything within that range is reasonable, then it can never be an abuse of discretion to sentence a defendant within the range once the defendant has been convicted.
Can you think of any other categories of cases where we would dismiss for lack of jurisdiction based on the specific claim alleged in a brief versus the category of cases or the type of order that's appealed?
If there are particular issues that a court would dismiss for lack of jurisdiction, such as a political question.
So I was thinking about that because you raised that in the brief, and wouldn't that just be a denial? So in other words, if it came up in the context of a writ of quoranto, we would have jurisdiction to hear the writ. We might deny it because the issue raised was a political question that we couldn't reach. But it wouldn't necessarily be a jurisdictional bar. It would be, it's similar to what we're seeing here. It's, you know, what's been appealed is the final judgment and sentence. The claim raised in the brief is this specific claim of abuse of discretion. I'm just trying to think of other contexts outside the cert context where we would just say we don't have jurisdiction to hear the case because of the specific claim raised.
I think this court has said that jurisdiction involves the power to hear a particular cause. So there might be jurisdiction with respect to the case, but not with respect to individual issues. So you might dismiss on the political question issue, even if you otherwise had jurisdiction over the appeal. I'm not aware of any other specific context at this moment. But as I was responding to Justice Kennedy, I think that this case is important for the ramifications it would have on other sentencing appeals. If this court determines that these Step 2 Banks denials are reviewable for an abuse of discretion, there's nothing special about the way the judge exercises his discretion at Step 2 as compared to any other in-range sentencing determination, and that could potentially open the floodgates for sentencing appeals in Florida every time a defendant simply thinks his sentence within the range was too harsh. Moreover, a petitioner has not asked this court to review a trial judge's purely discretionary, has not asked this court to recede from Brown or Davis, which state that these types of discretionary determinations at sentencing are unreviewable. And without having asked this court to do that, he cannot prevail. So if there are no further questions, for all these reasons, the state asks the court to approve the first district's decision.
Thank you.
Just a few points on rebuttal. The state said that there would be new appeals. I don't think there would be any new appeals. This would have to be raised in a direct appeal. I don't think a single new notice of appeal would be filed under the rule of law we're asking for, which, as Justice Kennedy said, I don't believe I used the phrase nothing burger in the brief, but I think it is a straightforward jurisdictional question. I think that's the term I used. And with respect to Davis and Brown, we're not just looking, I think the state is reading those cases too narrowly. We're not just looking at whether the sentence is in range. There's the legislature set out parameters for a downward departure. The trial court exercises its discretion. The appellate court reviews that exercise of discretion for an abuse, and whether or not it finds an abuse of discretion, the threshold jurisdictional question is met. There's a final order. There was a notice of appeal.
So am I right, when I was looking at the statute, it's written in a way that those criteria in the statute are not meant to be exhaustive, right?
That's correct.
It has to be just reasonable under the circumstances or something. So if you put this on the table as something that could be, even if it's a long shot in every case, does that have a de facto kind of effect of requiring the trial judges to give some kind of explanation on the record for their thought process for, you know, how they decided not to do it? I mean, because it seems like once I put abuse of discretion on the table, then I can either, if I'm, you know, an appellate court, I could maybe have a rule that says, you know, silence means I'm going to assume that the judge was, you know, perfectly wise and whatever. As soon as they open their mouth and I start scrutinizing the reasons given relative to what was in front of the judge and all that, I mean, how do we operationalize it?
I mean, as a defense lawyer, I would love that rule of law where they need to announce all of their reasoning, but again, there's the cited in the briefs for a different analysis for abuse of discretion, JMH for a sentence under Miller v. Alabama. The judge just has to say, I've reviewed all the factors, different statutory scheme, but the judge can just say, I've reviewed all the factors in the statute, I'm going to impose the sentence. On the way the case law has developed, they don't have to say any more.
So
to your-
maybe this is already true, but I mean, in a perverse kind of way, it sort of incentivizes judges to just issue these kind of edicts without explanation, because it seems like all you can do if you're a judge, if you're a trial judge, by explaining yourself is give, the geniuses on the appellate court something to pick over as to whether it was, reasonable what you did.
That extends to the appellate lawyers, but yes, that's well, I love when they do explain their reasoning. It's fair to say it may not always work to their advantage on appeal.
Loose lips sink ships. Right?
Sure. If there's no further questions, I'll waive the remainder of my time.
Thank you. We're going to take a 10-minute recess.
All rise. session. Please be seated.
Our third and final case for today is number 2023-1170, in re amendments to Florida Rule of General Practice and Judicial Administration 2.535.
Thank you, Your Honor. Chief Justice, members of the court, may it please the court, my name is Kristen Norris. I am the chair of the I'm the chair of the Rules of General Practice and Judicial Administration, and here on behalf of the committee today to present to you a proposal to amend in large substance Rule 2.535 regarding court reporting and transcription. And the purposes of the amendments that we bring to you today are to modernize the rule so that it aligns with current practice, to make the rule more readable, and to improve uniformity and readability of transcripts. I want to do a brief thumbnail sketch of how this proposal comes to you today and the process by which we've gone through, because I do think that's important. This proposal began with a referral from Attorney Paul Regensdorf, who passed on request from the Court Reporters Association to remove from the rule an obsolete requirement that transcript volumes be limited to 200 pages. And that was causing difficulties in the digital age for them. Mr. Regensdorf also suggested that there were other obsolete portions of the rule and it probably needed some serious updating. So the first task here was to send it to a subcommittee. We have a subcommittee of members of the committee that review the rule. They had a preliminary meeting, and then they had a secondary meeting where they did invite the Court Reporters Association to participate and to offer comment on a proposal that they had drafted. Thereafter, the subcommittee passed the proposal that they had drafted, largely in substance to what you see here today. There was a subsequent meeting in front of the full committee where, again, the court reporters were invited to participate and did attend and give us some insight into their thought process. And then, of course, it goes to the Florida Bar Board of Governors, another chance for the court reporters and the committee to weigh in front of the Board of Governors, which also passed the proposal. Once the proposal was filed with this court, there was, of course, another comment period, and we did have a subsequent meeting at which the court reporters came to talk about their comment and for the committee to respond to it. So I do want to take a minute to thank not only the members of the committee who've worked on this, but also the court reporters. They came to meetings, they were engaged, and while we disagree on some really three portions of this rule, their participation allows us to vet that rule and to bring it to you with as much information for you all to make the best judgment that you can on this rule.
Could I ask you about the indentation of the colloquy?
Yes.
I mean, I've looked through all this and the comments, and I'm just baffled, candidly, by the change in the rule to only allow the first line of a colloquy to be indented. I mean, as somebody who actually reads these things from time to time, right. And as a reader of other texts, I just find what is the rationale for that? And I understand there's some invocation of federal rule, but then I don't think it's in the federal process. So what does it boil down to?
I think the committee's position was that first double indent, that first 10-line indent, is the set-off. That's the visual cue that you need to know that we're departing from the Q&A and now we're into a colloquy, or we're into a paragraph, or we're into a quotation. But that once you had that first visual cue there, that you didn't need it, and particularly in transcripts where the colloquies...
smarter than the average bear, okay? Because I think... I still find that confusing.
And I think the other thing about that part of the rule is there's three different formats then, right? There's the colloquy format, which is double indent 10, subsequent lines 5. There's the paragraph indent, which is double indent 10, subsequent back to the margin. And then there's the quote indent, which is double indent 10 all the way through. And I think the committee's draft basically tried to simplify that. You get your double indent that tells you what's coming next, and then everything else is uniform.
What's your beef with 14-point font?
We don't have a beef with 14-point font. There's no beef with 14-point font at all. The purpose of the font requirement was to modify away from the monospace courier, which really has gone the way of what it was intended to mimic, which is the typewriter, and to then align the rule with the modern font. The current rule has a 12-point.
Okay, so
Could you raise it to 14? I think you could. Currently transcripts have 25 lines. I think if you raise the 14-point, then now you have different line setup, so you'd have to change that too.
Could you respond to the argument that this is about money?
Sure, I can respond to that. So, and I think that's an important thing to respond to. It is not about money. I think when you look at the totality of the rule change, the one money issue here is the double indent, single indent.
No,
I mean, that's the one thing.
The font size is also about money.
Well, the font size is currently 12, so we're not changing the font size.
Any change that affects the number of words on a page and therefore the number of pages is in some sense about money. So I'd like to hear from you your answer about why you've not been driven by those considerations, or if you have been, why it's okay for you to be driven by those considerations. But show your cards.
Oh, sure, and I'm not trying to hide any cards. We are a democratic process. I have a number of committee members, over 30, who vote their conscience on these. So I can tell you what we discussed, and I can tell you, I think what happened here is at the subcommittee level, as pointed out in one of the declarations, there was an attorney on the subcommittee who commented that transcripts were his biggest cost. And for that attorney, that was a consideration. In subsequent meetings of the committee, members of the committee, other members of the committee, many other members of the committee said, I'm not worried about the cost because I don't think this is going to change the cost. We can change font sizes, we can change pages, we can change whatever. Nothing about this rule is going to bind the court reporters to then reduce their costs. They can modify for it. So on the font sizes in particular, we maintain the same font sizes. So we're not looking to decrease pages with the font sizes, same number of words, same with the margins. So the indents are the one potential area where, yes, they could result in shorter page numbers, particularly in trial work where there's a lot of colloquies. So, but the committee discussed and the court reporters mentioned at the committee meeting, et cetera, that doesn't mean that they can't then raise their per page rates or shift like the appellate rules have done to a more maybe level the playing field per word count. And so I would tell you there may be members of the committee that thought, well, this might reduce word counts and this might, have a lesser bottom line. And as the court reporter's comment points out, that's not necessarily a bad thing because the rules talk about making litigation less expensive. But I don't think that was what was driving the committee. And in fact, in subsequent meetings, that was a common theme. Like, we're not trying to prevent you from making a living. We're not trying to take away money from you, but we do think in good conscience, the majority of the committee thought this rule works better. This rule works better.
I've had a lot of experience with court reporters. I was a trial lawyer, and then I was a circuit court judge, and the court reporters work really hard.
They do.
And they're the forgotten one in the courtroom. Lawyers are talking in circles, and they could talk all day long and forget that there's this person there with the fingers going. Definitely. And don't concern ourselves with giving them breaks because we're in the middle of an important argument. And how about readbacks back in the days when we didn't have the tapes, and the court reporter could read back 2 hours of testimony in 20 minutes. Whereas now we have to hear a tape in real time. It's 2 hours. They're an important part of our judicial system. They work hard, and when the courtroom session is over, they have to go back and dictate those things. Or now, of course, they got machines that have memory. But I'm not all that concerned about the money part because I think they earn it. But let me just ask you: you have a 1-inch margin.
Yes.
On all sides. Do we have a margin limit now?
We actually have Rule 2.520, which does require that all documents, and documents is actually defined very broadly to be and include any paper or writing submitted to a court, to have a 1-inch margin on all sides. Yeah. So what you'll see, and this is one thing, I would say this, right now there's no margin requirement in the rule. I guess according to the court reporter's historical knowledge, that was deleted as obsolete at some point because of the type requirements. But when the committee pulled separate transcripts from their files, we saw all manner of margins. Some transcripts already are printed on a full 1-inch margin. Some transcripts adopt, I think we cited the Federal Court of Claims rule. They do a 1 3/4 inch margin and a 3/8 of an inch margin. Effectively, they're moving the box over to make a lower margin on the right. Same amount of space, 1/8 of an inch difference. So that wouldn't change page numbers, or the font change wouldn't change page numbers. It is the indents, and there was really just a difference of opinion on how this is going to look, I think. But we do have 2.520 with the 1-inch margin on all sides, and the committee felt like it's easy, it's consistent, and that was the best practice.
Can I ask you a question about the font itself?
Yes.
So it seems that in the pleadings there was this sort of claim that it was to be closer to the appellate rules requirement.
Correct.
Today you've said it's to modernize. So kind of what was the goal with the font choice?
Right, and I think there's an overlap there. It's a Venn diagram. When the Appellate Court Rules Committee looked at changing the fonts, they did a bunch of research on that, right? Mm-hmm. They looked at ADA compliance, they looked at readability, and they looked at, and then they actually, I believe, did a survey of judges and lawyers, right, and settled on that these two fonts were the easiest on the eye, particularly for screen reading, the most accessible fonts.
Right.
And so really when I talk about modernizing, I'm talking about that. I'm talking about we have modern sensibilities where we're used to reading a proportionally spaced font. We recognize that that is easier to read than this spread out font where the little I has as much room as the capital W.
Sorry,
yes.
Go ahead.
Yeah.
I think it's more readability, because that was my question. Yes. It's like, what is the value behind modernizing? Right. And I have the same question for, you mentioned uniformity. What is the harm with the non-uniform? Isn't that just a market issue? If you like this court reporter produces a transcript in this font, in this manner, you use that court reporter. So I guess, can you address, in terms of uniformity, what the harm we'd be looking to correct is?
I think we just expect in a court record for things to be somewhat uniform, and find that in scrolling through, uniformity helps breed immediate recognition. For example, I think it's important that our transcript pages have that box, right? When I'm scrolling through, I want to see that box. And so I think uniformity, the committee's feeling is that uniformity sort of breeds immediate recognition. We know, and consistency, that is helpful. And the readability, I think, is important. We have moved on from the old fonts because we find them easier to read. And I do want to point out, because I do think the court reporter's comment was very helpful in this regard, that they've, in their appendix, they've provided like 3 exemplars. One is what it would look like, one is what a transcript looks like now, one is what the rule would change a transcript to look like with a Bookman, and one is with the Arial. And that's what I would point the court to, because these are very subjective things. I like Bookman. Some people will die on the Arial Hill. But I think there is objective evidence that the fonts that are proportional are more accessible, they're easier to read, they're easier on the eyes. So that, I think, is an objective measure. But subjectively, whether we indent 10 spaces for this and 5 spaces for that, et cetera, these examples that they've given cover all of those parameters, so that the court, who reads probably far more transcripts than many of the attorneys do, can make their own judgment and decide between these. I would say there are many other things that have not drawn any criticism in the rule. For example, requiring the PDF format that is standard now, requiring text searchability, requiring they be printable now instead of printed. And the comment mentioned at the end that they were seeking to reject all of the changes except for the removal of the 200-page limit. But none of the changes in A through E or G through J have drawn any criticism at all, despite the process that we've gone through. We really are down to the margins, the indents, and the fonts. I want to return to the fonts one more time, because when we did the fonts, we accepted the 12-point that is currently there. And it is our experience that Although appellate courts have widely moved to 14, the trial courts are still largely using 12. If you adjust the font size up, then you do reduce the number of lines that'll fit on a page to 24. And so it seemed easier to keep that current standard as long as we approve the font type. So that was the reasoning behind that. But again, I do, unless there's any other questions, I do thank the court reporters for their participation, the members of my committee, and also the court for its consideration.
Thank you, and you can add 2 minutes for rebuttal.
Thank you, Your Honors. May it please the court. Jason Gonzalez on behalf of the Florida Court Reporters Association, and I have Laura Landerman, the immediate past president, who was president when this began, and Kelly McCall, who had asked for the 200-word limit to be removed for each volume of a transcript, and then it's not a controversial change. And we have the utmost respect for the committee and the work that they did, and I hope nothing that I say criticizing some of the additional proposals is seen in any way as any disrespect for the hard work of the committee. The court reporters did later receive the unpleasant surprise of these additional changes to the transcript rule in F, and there's some things there that they immediately recognized would cause detriment. And that draft was developed by that subcommittee. It even had a vote that was done by email before the court reporters learned of it. So they were well down this path on these changes, and there's no evidence that prior to that the committee or the subcommittee had consulted somebody with some expertise in computer-aided transcription software, which is what the court reporters use. It's not Word. They're not creating these transcripts in Word where you can just alter fonts. Computer-aided transcription software utilizes the non-monospaced font. Typically, they will use the Corel, 56 characters per line, 9 to 10 characters per inch. It's very uniform, and it's uniform throughout the country. And just to really illustrate the problems, rather than just repeat the things in our comments, but to illustrate the problems, let me give you an example from an actual deposition and what would happen if these other 3 proposals were added. I had a deposition 2 weeks ago in New Smyrna. I leave the deposition, and a few days later, I'm given a transcript, largely free of, it was free of errors. There was a lot that went into that when I left the deposition that the court reporters did. And if you adopted these rules, here's some of the things that would happen that would cause delays, that would cause statistically a higher chance of errors. So the court reporter then takes the raw file that they have in the computer-aided transcription technology software, and they would have it under the new rule formatted then under these outlier Florida rules that are different than their court reporters and other professionals in this industry use throughout the country. So you'd have the different margins. You would potentially have Bookman old style non-monospatial font. And what happens is they typically will send that file then to a scopist. And these scopists work remotely all over the country. It's going to go up into Eclipse or one of the other 3 programs that use this CAT software. And for instance, the scopist in Atlanta is going to then pull that down for that project. And they're going to have all the formatting set up that they use everywhere else in the country. So it's going to convert, and it's going to move things around, and they're going to go do their proofreading and change words, acronyms from the CAT system, and they're going to move everything around. They're going to do all their proofreading. It's going to take extra time because it came off of a Florida formatted CAT system. They're going to upload it again in Eclipse, and then it's going to be pulled down by my court reporter, and it's going to convert back because my court reporter's got her system set up with these uniform 1-inch margins, potentially the Bookman old style on monospatial font, and indentation, a different indentation. They're going to have to go back because every time you convert one of these files, there's problems. And now they're going to have to go through line by line, page by page, and find where a word was out of place or split up, and readjust that in their CAT system that again is supposed to be using a non-monospatial font. So they've added extra time on their end, and think of what that does to the index that was also reviewed by the scopist and edited. Now the number of pages has changed. So the index that has now moved around all kinds of pages. Then when they finally do that, I get my transcript. It's taken an extra day or two. My court reporter's been in other depositions and things. They've fit in extra time to review it again. It comes back to me. I print it out because I read everything in paper, and my assistant puts it in a 3-ring binder. And the hole punches have now taken out some of the line numbering. And in my example, my deposition 2 weeks ago was videotaped. And that means my transcript has, in addition to those line numbers along the left-hand margin, it's also got the timestamp so that I can go to the video and find exactly where it corresponds. Now, I appreciate that the committee put in their response to our comments that, well, for that, we would not object to the court adding to that line that those numbers for the timestamp and the line numbers could be moved outside the 1-inch margin, which would solve my problem with the hole punches taking out some of that data. But I think the easier solution to that is just don't adopt those parts of the rule. We don't need to add additional language to fix the problem being created by the rule.
This practical type question, given the procedure they would have to go through. So you're in the middle of trial, and you finish today, and you want a transcript tomorrow for tomorrow's cross-examination or tomorrow, whatever you're going to do. Would they have to? Typically, they work. You know, they have the memory on the computer on the machine, and they can get it out to you tomorrow. We go more expensive, but under this new system, they would have to go through that process you described. For how am I going to get a transcript tomorrow if I need it?
Right, potentially 2 or 3 conversions if they go to a scopist, and they also use different professionals called proofreaders, which they convert the file to a PDF and send it to a proofreader who doesn't edit like a scopist.
At the risk of using 2 letters that are probably horrible in this community, AI, I look at the rule and I ask myself, what rule can we adopt here that will survive the next 48 months, say, of evolution in generative AI? And approved court reporter is defined, but scopist is not, and proofreader is not. So if there is a large language model enabled proofreader or scopist developed in the next 12 months, am I right that the rule as amended is still going to yield predictable results? In short, I would hate to be back here in a year or two reworking this rule when this industry, please don't take this the wrong way, goes through the same revolution that every single industry is going through right now.
Right. Well, right now there is a conventional national standard. My transcripts don't look dramatically different when I took a deposition in Detroit a while back. There's not a national adopted standard. There's CAT software that is used universally, and that results in the format that we see. I don't think anything needs to be changed in the transcript rule. And I think if you look at the side-by-sides on page 12 and 13 of our brief, I think that nothing needs to be changed there. I think that I know it's subjective to some degree, but I largely prefer, overwhelmingly prefer the one on the right that's under the existing rule. In the indentation situation, that caused me the same concern Justice Kennedy brought up. And when I got my transcript back from the depo 2 weeks ago, I'm going to the index looking for a key word that was an important part of the deposition because I want to see if that exchange came out as good as I thought it was going to be or as bad.
Can I ask you a much more boring and simple question? Do you guys, what's your position on those other changes? Because I didn't see, I know the comment basically just says all you affirmatively want is the getting rid of the 200-page thing, but I didn't see any critique of the stuff that other than what we're fighting over right now.
We don't have any issue with all the changes they suggested outside of F, the transcript rule. We focused on the 3 really detrimental parts of what they changed in F, and the use of PDFs, especially if there's non-monospace font, that causes big problems when the formatting happens. But no, outside of leave the transcript rule alone. The other things, we have no issue that we're taking with those. And along the lines of the money issue, I think it's worth noting, when Mrs. McCall proposed the discrete change of getting rid of the 200 volume limit requirement, think about what that does. If you have, under the current rule, a 215-page transcript, they have to go to another volume, which means that they're going to have in the second volume a title page, another index page, an appearance page, a court reporter certification page, and a fifth notary certification page. That's 5 extra pages for every additional volume as it goes longer. That's $4 to $5 for every additional page. And if it's expedited, it's twice that much. So they knew when they proposed this, they're actually going to make less money. But they're proposing something for all the right reasons. That 200-page limit needed to go away. So they brought this to the committee with no financial motivation. Those on the committee brought up they're looking for ways to change some things that I think take the visual cues away that we need for those quoted areas. They don't make it more readable. And there was no outcry from the bar to change things that are readable. We don't know of any survey that was done that you would show a side-by-side and let people pick. There's no overwhelming outcry for this, and the committee was split. I think there was a third of the committee dissented, and I'm told that's very unusual in this type of process. So I don't think that anything's broken that needs to be fixed in those respects, and that you should just, as far as the transcript section, only include the change to removing the 200-page limit.
Did I understand that there really isn't a software available that uses this type of font?
That uses
the classification of font?
The CAT software is not the Arial and the Bookman Old Style. Every court reporter in the country is using the CAT software, which functions properly with the non-monospatial font. As they mentioned, it mimicked typewriter when they converted over to that. For me, it's visually, the equal-sized characters across the sentence look better, and you can look at the side-by-sides. You have different fonts, if you're in Word, which they don't use, that will kind of scrunch up the characters in a non-monospatial font. I think it looks better the way we have it right now. So I just don't think there's an overwhelming consensus to make the change, and it creates all kinds of formatting issues, which slow things down. And AI would not affect our current formatting we wouldn't have to change.
Well, yeah, but my question wasn't so much about formatting. My question is about a world probably not too far off, where I can say, hey, Llama, listen to this 3-hour deposition and transcribe it for me, meeting the following characteristics: 1-inch margin, monospace type, and it spits out something serviceable that, needs to be processed. Now, I've got a rule that requires an approved court reporter, right? So the court reporter is not going away. But my point was these other layers that you're talking about, the scopist, the proofreader, those seem like really dangerous places to be, because those are skills that I'm willing to bet AI could probably already annihilate today if somebody was smart and moving in this space. And my question was, are we adopting a rule that will survive that? Because I don't think that is too far off. I think the answer is yes.
I think it's possible. I think there will be changes that have to be made to update for technology from time to time, and the court reporters have gone through technology change after technology change. They adapt to that. This just doesn't make it any more readable. So whatever AI is going to lead to, but you don't have, the court reporters in Florida aren't regulated like they are in, for instance, California. The last point, the appellate rules that were mentioned, they exempt the transcripts from those. Those are parameters for the briefing, and they specifically exclude the court reporter transcripts.
So you had me scared, no Coriel's. I mean, I'm going to be a basket case by the end of this thing. Do you have anything else?
I have nothing else.
Okay. Thank you very much.
Just a couple of brief comments. So we also were concerned as a committee with the question that was raised in a comment about the software, because that would be the most compelling argument. So we went back with the question, can the software do this? Because if it can't do it, that's one thing. If it can, but it's complicated and you have to jigger this and jigger that. And we were told that the software can do it, and the appendices show that it can be done. But that the concern was adapting to that technology and changing the way you do things. And I think it was expressed by the committee, but I will express it here. I am not unsympathetic to that. I know many a lawyer who'd still be using WordPerfect if they were allowed to do so and could actually operate.
But seriously, though, I mean, put yourself in our shoes, and, you know, there was this kind of, you know, unanimous consensus kind of 200-page thing. Right. Now we have people who make a living doing this and who are way more up to speed on the technology and on the logistics and the practicality. It doesn't seem like the reasons for the changes are particularly compelling. I mean, why would it make sense for us to adopt these changes? And it's not a rhetorical question. I mean, put yourself in our shoes. Why, sure, in the face of this, why would we do it anyway?
I think you do it if you believe that the transcript is more user-friendly in the new format. I mean, that's why you do it. And it's why we adopted PDF and PDFA. I mean, there's reasons sometimes to modernize, and the committee believes, particularly with the monospatial font changes, et cetera, that it's time to do that. And there are learning curves. We definitely understand that, but we are in a place, I do think that we are in a place where the technology is easier to make adjustments to. And so is there going to be a painful period in the beginning? Yes. Is it worth it in the committees, in the majority of the committee, the majority of the Board of Governors? Is it worth it to have a transcript that looks more like our other documents that we're used to reading, that seems more readable to us? The committee believes so. But it is something that the court is looking at the whole system, and court reporters are a part of that system.
Am I right, though, that is the status quo that if people wanted to, you know, change the way they do things and sell this stuff, would these changes happen naturally, would the current rule permit it?
I'm sorry, I'm not.
So I know that right now your proposal is that we mandate all these changes.
Right.
Is the rule that's on the books right now, if for some reason everybody decided, hey, these things aren't user-friendly enough, we want it, is there anything stopping the world from adopting
the rule
these?
says courier or mono. I mean, so there are restrictions in the rule. There are no margin requirements.
In terms of the margins, though, and this indentations and everything.
Right. And I would urge the court to do a margin requirement. I mean, I don't know why it was taken out. And there was some discussion about a national standard. There's really no national standard. It's true, I have not been able to find another court that has gone away from permitting the courier type. I could not find that, so I agree that that's probably true. But different indentations, different margins. But we would ask you to adopt some margin requirement, because we did pull different ones and the margins are all over the place. So whether it's 1 3/4 and 3/8 or 1 all around, it makes sense to have a margin requirement. For the same reasons we have word counts, et cetera. Like, let's have some uniformity and make sure that the level playing field there. So.
Okay, and thank you, and we really do appreciate. We appreciate all of the rules committees, and
we know that we appreciate our liaison and the work that the court does on this. Thank you, and again, the court reporters really have been wonderful to work with, and we're very passionate, and they're professionals, so we do appreciate that. Thank you.
Thank you. We're adjourned.
All rise.